সুপ্রিয় শিক্ষার্থী বন্ধুরা, আর একটা ক্লাসে আমাদের সুস্বাগত। আমাদের আজকের আলোচ্য বিষয় হচ্ছে ইন্টারন্যাশনাল এনভায়রনমেন্টাল ল ফর ফাইনাল এক্সাম, কোশ্চেন কোড 102, ঢাকা ইন্টারন্যাশনাল ইউনিভার্সিটি। First question: define role of international environmental institution like UNDP, United Nations Development Program, and WTO, World Trade Organization. International institutions shape the global environment through distinct mandates. The UNDP integrates sustainable practices into poverty reduction, while the WTO manages the intersection of international trade and environmental regulations to prevent green protectionism. Number one, United Nations Development Program (UNDP). The UNDP's role is to eradicate poverty while protecting the planet by integrating environmental sustainability into national development plans. Climate action resilience. It assists countries in implementing their nationally determined contributions like NDCs under the Paris Agreement and building resilience against climate impacts. Environmental financing. As an implementing agency for the Global Environment Facility GEF, the UNDP directs funds towards renewable energy, biodiversity conservation, and ecosystem restoration in developing nations. Policy integration. It works with local governments such as the programming done in Bangladesh to align economic development with UN Sustainable Development Goals (SDGs), especially focusing on clean water, climate action, and sustainable cities. Number two, World Trade Organization or WTO. The WTO's primary mandate is to regulate global trade. However, it plays a critical role in global environmental governance by addressing the intersection of trade rules and environmental protections, balancing trade and environment. The WTO enforces rules ensuring that environmental regulations like carbon border adjustment or eco-labeling are not used as disguised protectionism or arbitrary barriers to international trade. Environmental agreement. It provides a forum to discuss how multilateral environmental agreements interact with global trade law, working to ensure that trade policies and environmental sustainability are mutually supportive. Subsidy discipline. The WTO negotiates the enforces agreements aimed at eliminating harmful government subsidies such as those that contribute to overfishing, thereby promoting sustainable resource management. Our second question number two, settlement of international dispute under international environmental law, ITLOS. The International Tribunal for the Law of the Sea, ITLOS, settles international environmental disputes via Part 15 of UNCLOS, focusing on marine pollution and conservation. Located in Hamburg, Germany, its jurisdiction covers compulsory binding dispute resolution, especially chamber for specific environmental issues and advisory opinions on ocean sustainability. ITLOS utilizes several frameworks for handling environmental and transboundary disputes. Number one, jurisdiction and mechanism. A state involved in maritime environmental disputes, that is, vessel dumping, habitat destructions, or pollutions, can submit claims to ITLOS through three main avenues: continuous cases, binding dispute settlement for states parties to UNCLOs, covering the interpretation of Part 12, protection and preservation of marine environment. Seabed Dispute Chamber handles dispute related to deep seabed mining and activities in the international seabed area. Provisional measures. ITLOs can quickly prescribe emergency measures such as ordering a halt to harmful activities to prevent irreparable damages to the marine environment while a case is pending. 2. Key environmental principles applied. When arbitrating cases, ITLOs release on customary international environmental law and general UNCLO's clauses. Its jurisprudence frequently invokes the precautionary principle and the duty to cooperate. Environmental Impact Assessment or EIA. Question number 3. History of international freshwater law: navigation era, non-navigation era, modern era. Write details about International Law Commission. Describe Article 3 Water Courses Agreement and write names of all general principles of Water Course Convention. International freshwater laws evolved from focusing merely on interstate commerce and border demarcation to prioritizing sustainable, cooperative, and equitable management of shared transboundary resources across surface and groundwater. The history of international water law can be categorized into three main areas: history of international freshwater laws, the navigation era, early 19th century to early 20th century. During this period, the primary focus of international river law was ensuring freedom of commerce and transit for ships. Treaties such as the Treaty of Paris 1856 and the Barcelona Convention 1921 were established to secure rights of passage and maintenance of river waterways. Number 2, non-navigation era, mid 20th century. As population grows and industrialization increased, the demand for water shifted towards irrigation, hydropower, and flood control. Treaties and legal doctrines began to emerge that addressed the allocation of water. Helsinki Rules 1966, drafted by the International Law Association, marked a major milestone as the first comprehensive attempt to codify the principles of international drainage basin law. Modern era, late 20th century to present. Modern era center on the integrated management of water resources, ecosystem protection, and sustainability. It is defined by landmark global treaties like the 1992 UNECE Water Convention and the 1997 UN Convention on the Laws of the Non-Navigational Uses of the International Water Courses, UN Water Courses Convention. The International Law Commission (ILC). The International Law Commission is a subsidiary organ of United Nations General Assembly established in 1947 to promote the progressive development of international law and its codification. Following a request from the UN General Assembly in 1970, the ILC conducted a long-term study of international water courses law, culminating in draft article in 1994, which formed the foundation for the 1997 UN Water Courses Convention. Article 3 of Water Courses Agreement. Article 3 defines the relationship between the Convention and specific agreements, ensuring that existing treaties remain valid while encouraging states to harmonize them with the Convention's principles. It affirms that states may enter into a specific agreement for shared water courses provided they do not negatively affect the rights of the other state. Article 3 of the UN Water Courses Convention concerning non-navigation use of the international water courses establishes the legal frameworks for water course agreement between countries sharing transboundary waters. It outlines the following core principles: recognition of existing treaties, encouragement of harmonies, negotiation of new agreement, impact on other states. Agile principle of the Water Courses Convention 1997. The 1997 Water Courses Convention establishes core principles for the sustainable and equitable management of shared water resources, including equitable and reasonable utilization, Article 5, non-significant harm, Article 7, cooperation, Article 8, data exchange, Article 9, prior notification, Part 3. Question 4. Explain equitable and reasonable water courses according to Article 5 and 6 and Article 7 not to do any significant harm. Under Article 5 and 6 of the UN Water Courses Convention, states must utilize shared water courses in an equitable and reasonable manner to attain optimal utilization and benefits while factoring in vital human needs, ecological protection, and the specific economic development of each affected country. Here is how these core principles and the no harm rules balance transboundary water rights. Number 1. Equitable and reasonable utilization. Article 5. This principle guarantees riparian states on riparian states and equitable of rights to use the benefits from the shared water course. It does not mean splitting the water into identical 50-50 portion, but rather ensuring that all states sharing the basin can benefit fairly and sustainably. Number 2. Relevant factors for determination. Article 6. To ensure a use of considered equitable state must holistically evaluate a comprehensive list of geographic, socio-economic, and ecological circumstances. Key factors include natural elements, human dependency, downstream impacts, and conservation. Obligation not to cause significant harm. Article 7. This no harm principle mandates that a state must take all appropriate due diligence measures to prevent causing significant harm to other watercourse states. The threshold. The harm must be capable of being established by objective evidence and cannot be trivial. Reconciling the articles. In international water law, no significant harm is typically interpreted as a critical component of achieving equitable and reasonable utilization rather than a strict ban on any change. If significant harm does not occur, the contributing state must consult with affected state to mitigate its impact and may be required to pay compensation. Question 5. Describe historical background of international climate change law. Explain Kyoto Protocol Paris Agreement. International climate change law evolved rapidly from international scientific conference in the late 20th century to binding global legal framework. The international climate regime is built on three fundamental pillars: the UNFCCC 1992, the Kyoto Protocol 1997, and the Paris Agreement 2015. Significant awakening and the foundation 1979 to 1992. In 1979 World Climate Conference. এরপর হচ্ছে 1988 সালে ক্রিয়েশন অফ দ্য আইপিসিসি ইউনাইটেড নেশন এনভায়রনমেন্ট প্রোগ্রাম ইউএনইপি অ্যান্ড ওয়ার্ল্ড meteorological organization WMO established the Intergovernmental Panel on Climate Change IPCC to evaluate climate data and provide scientific consensus to policymakers. 1992 Earth Summit UNFCCC. At the DIU Summit, nations adopted the United Nations Framework Conventions on the Climate Change UNFCCC. It established the ultimate objective of preventing dangerous anthropogenic interference with the climate system and introduced the critical principle of common but differentiate responsibilities, assigning more responsibility to developed nations. The Kyoto Protocol binding commitments 1997. While UNFCCC was a fundamental framework, it lacked legally binding emissions target. In response, the parties negotiated in Kyoto Protocol 1997. It legally bound developed nations annex one countries to reduce their greenhouse gas emission by average of 5.2% against 1990 level. It also introduced market-based mechanisms like the Clean Development Mechanism (CDM) and emission trading to help countries meet their target. Paris Agreement, Universal Action 2015 to replace the expiring Kyoto Protocol in Protocol 196 parties at the 2015 UN Climate Change Conference COP21 adopted the Paris Agreement. It marked a fundamental shift in the international law by setting universal long-term goal to keep global temperature increases well below 2 centigrade above pre-industrial level while pursuing efforts to limit the increase to 1.5%. Instead of top-down legally mandated target, it operates a bottom-up approach where nations submit nationally determined contribution and disease detailing their domestic mitigation and adaptation plans. Number 4. Recent development and the path forward. The Katowice Rulebook 2018 was established to operationalize the Paris Agreement, creating uniform guidelines for how countries take and report their greenhouse gas industries. International integration has increasingly intertwined with law landmark legal developments such as the International Court of Justice and unanimously affirming that states have legal obligation under climate change treaty law to reduce greenhouse emissions continue to shape the enforcement of these historic agreements. The Kyoto Protocol 1997 was the first legally binding international treaty requiring industrialized nations to reduce greenhouse gas emissions. The Paris Agreement 2015 is a broader legally binding UN framework requiring all nations, both developed and developing, to set individual emissions target to limit global temperature increases. The Kyoto Protocol 1997 scope and target. It adopted a top-down approach primarily mandating 37 industrialized countries and the European Community to cut their greenhouse gas emissions by an average of 5% below 1990 levels during the first commitment period 2008 থেকে 2012 developing nations and market mechanism. The Paris Agreement 2015 core goals the accord aims to limit global warming to well below 2 centigrade above the pre-industrial level while pursuing efforts to limit the increase to 1.5 centigrade. It also aims to global emissions to peak as soon as possible and achieve net zero emission in the second half of the 20th century. Nationally determined contribution and disease. Rather than composing top-down targets, it required all 196 participating parties to submit their own climate action plans and disease and continuously update them with increasingly ambitious goals every 5 years. Transparency and support. It relies on robust transparency and accounting framework to track progress as well as financial and technological support to help developing nations build resilience. Thank you very much.